Law matters, of course it does. Welcome once again. I'm Debbie Moraes, your host and moderator. This long-running program continues to provide legal information, relevant examples, and practical assistance to help you with law matters because the law matters. Understand the law better, and you're in a better position to decide how to protect yourself, your family, and your business. As we present various topics, you may decide that you can actually handle some issues yourself. If you do decide to seek outside professional counsel, they'll be better prepared, you'll be better prepared. Our goal, of course, is to help you achieve the best possible results while saving time and money, as always. We again want to thank and welcome Attorney David Bizarre from the Bizarre and Associates law firm in East Providence, who continues to provide us with legal information and his professional insights in each session. And today we're going to be discussing wills and estates, part two essentially. Earlier we had discussed wills and estates I guess in the height of the pandemic. So many people were panicked that they would be incapacitated or die, and what should they do? So now, since the vaccination is around, many more people are thinking they might actually live. They are likely not to be separated from their family. They might have other choices that they need to make, other plans that they need to consider. So today we're going to discuss what you need to know. Those plans might change because of what's going on in the administration, what's going on with various capital gains issues that are up in the air right now. So David, let's start with a little tutorial. How has life changed somewhat post-pandemic for you when it comes to wills and estate planning?
So people are more willing to come into the office now that we are getting vaccinated. We've always had, since the pandemic began, instituted a lot of different rules and regulations about COVID screening and cleaning the conference room, rotating chairs out, rotating conference rooms. So we've done everything to keep people safe, but people are starting to be more comfortable about saying, all right, we've done our meetings on Zoom, we've done some design on Zoom, I know I have to come in to sign, let's just set that up and get that going. So it's really busy with estate planning, and we're also unfortunately very busy with estate settlement as well. And so the things that I see people looking at more now is my whole estate plan and everything I need to do, whereas earlier on it was healthcare documents and worrying that everything I need to do and the people I want to make decisions was in place.
Did you find, I know I'm not as preoccupied with my own mortality as I was in the middle of all of this, but when people were coming to you then, were they making decisions that you see they might not have made if it weren't for the fact they were in a pandemic? For example, maybe they selected their next to make the decision, the one who's closest to them physically, because someone halfway across the country couldn't, for example, move in and pay their electric bill or their tax bill while this was all going on?
So we've always approached estate planning from the point of view of the advice that we can give. And so we dive into great detail in depth with people when they come in about not only what the assets are as we're doing the planning, but who are the players, who's the family members, who are the friends, who are those that are best suited to provide the help that you need in different areas. And there are different areas. There's financial areas, there's health areas, there's people who are close that might be able to help while you're here but maybe become incapacitated. There's a lot of different things that go into selecting the right people. And part of the process and part of the service that we provide is making sure my clients go through the thought process of examining what each role is and who's going to be best able to serve that role. So the process didn't change, even though some of it was by Zoom instead of in person, in terms of trying to talk through making those decisions. So I don't think the decisions that were made would have changed. I think the idea that people started to think about it is the only thing that was really affected by the pandemic.
Did you find that people were quicker to just get it done because they were panicked, and now perhaps a little less so? Now they're more willing to sit back and think a little bit more, have another conversation than they did before?
Yes, I think that there was some rush. I need these documents in place. all right, this is what I want to do, let's just get it done. Whereas now it might be two conversations about the process and how everything works and a little more thought put into it. But again, I think we tried to make it thoughtful so that the result would have been the same, and I do believe for the most part it was. But there's a little less anxiety, I think, about, I got to get this done right away for the most part.
So comment on this, if you will. Understandably, most people have known that online helps. People Google everything. I'm sure that while people were sitting at home, they would know that they need to take care of things, but maybe were afraid to, so they went and did the famous Google search, which would have turned up things like Legal Zoom or Rocket Lawyer, and some of those documents they can get done. One you can get done, I read, for $39, another one for $236. You can upload those documents and they can be accessible online. Imagine if you were the doctor or maybe the nurse or someone on the front lines, and you have to serve, ungodly shifts. You don't have time to start thinking of all these things, but maybe in the middle of the day or the night, whenever you have a moment, you look online. So people did these things, perhaps in haste, as I was just asking if they might have hastily done some plannings of wills or whatever. What do you think about some of those documents that are just done online and without benefit of counsel?
So the question, I guess, that you always like to ask in these types of, in the show is, can you do it yourself? Can you go online and get your own documents and do it yourself? And the process that we handle and what we do isn't really about the documents. The documents may be the final product, but it's the advice, the conversation, the thought that's put in, because there's a lot of different ways that you can leave property to somebody else, whether it's through a will or through a trust or by gifting. There's tax consequences that need to be thought of. And you really have to think about, well, I want to protect my house, I want to give it to my children. Do you really want to do that? Because are you doing a service for your children by doing that? Are you giving them a house that you bought in 1959 for $10,000 that they don't live in, so when they sell it, they're going to have a big capital gain? Is there a better way that you could leave it to your children so that they don't have capital gain? These are all parts of small snippets of things that need to go into a thought process of how we're going to leave our property to the next generation. And that's only one aspect of what needs to be talked about when you talk about estate planning.
So I think that you make a good point about how you have the time and the wherewithal and the means and the understanding to ask all of these questions. And of course, I can understand on the other side of it, if someone's desperate and they just think that they must get it done immediately because there's a nurse and they're in the hospital all the time and they could die tomorrow, and what should they do? And I understand that feeling of desperation, which now, if they have survived, hopefully we know many have, they can take a deep breath. So even if they've started these documents and they've done them online and they're hearing programs such as this, or they're reading more about what to do post-COVID, might they still be able to say, okay, David, I've done this much, counselor. Now I should meet with you and let's see if we can step back, take the mile-high view and discuss this, explore it more.
I have a lot of clients who come in for the first time who have done some documents or have old documents, but usually, let's just talk about the example you gave. They did something online and they want to bring those documents to me. They've come in, I've looked it over, we've talked. Sometimes, not too often, sometimes some of the documents actually do what they think they're going to do and what they want them to do, especially some of the healthcare documents and that type of thing. But not always, and it doesn't always cover everything they really wanted or should have had in those documents. But if they do, I'll tell them, yep, you got your healthcare document in order, it's in good shape, and it's fine. Sometimes they'll come in and they weren't actually executed appropriately, so yeah, it has what you want in it, but it's really not going to meet the statutory requirements of who can sign it and who can't sign it, so we may need to fix that. But I'm more than glad to meet with a client who has done something, review it, and if it's correct, I'll tell them, yep, you don't need me, this has covered what you want to do, and you've done it in a correct manner so that it's executed properly, and you're fine, and I'll tell them that. But if there's something that could be improved or some thought of what they haven't put in, something they haven't actually thought of that needs to be put into it, we'll have that discussion. And then if I can help them do that, I'll do that.
We often say that we like to provide resources and some idea about how someone could do some portions of this themselves. If they've just started to think about this by looking at something online, perhaps they have at least a head start, if not a complete solution. Now, when we talked about wills and estates earlier, I know that you've made the point that some people can have a very simple life, perhaps, and can do this very easily. Even if you have a simple, not complicated situation with many businesses and properties and investments, is it still worthwhile to have a true professional person eyeball it, just as you're saying, to make sure that it's legal and as it should be?
Absolutely. To make sure what you want is going to be accomplished by the documents that you have, to make sure that they'll work the way you want them to work. I was actually just having a conversation with a friend of mine who is the finance manager at Elmwood Dodge. And he said someone came in with the power of attorney that they had done on the internet, and he's looking at it, and he knows what they want to do, and they're coming in to help their mom or dad, I don't remember which, do some financing on the car and get the car that they wanted, but the parent wasn't able to, maybe they were out of state, I don't know. But it was all legitimate, except the document didn't have the language in it that they needed to have in there for him to be able to get them financing and let them do what they needed to do.
Really?
And it wasn't executed properly. And so he felt really badly, but he said, I had to tell them, your mom or your dad, whoever it was, has to come in, because either they have to have it done over so that I can help you, or they have to come. And it's unfortunate, but this is sometimes what happens when you try to do it yourself.
Good point. And fortunately, in that situation, it wasn't a life or death situation, but something that could be handled and managed, and there's time enough to do that, fortunately. Right. We are now in a change of administration since we last presented this information. There are things that are in flux. People who care about their investments, their retirement, their capital gains, all of those things are in flux right now. What would you say to people who've done an estate plan even in the last year? Do they still need to go back to you? Often we said maybe it's 3 to 5 years if something drastic hasn't changed in your life. How would you address that now, David?
Well, as you sort of hinted at the beginning, there are changes that may come with the new administration. There might be some changes with the ability to have a step up in basis for capital gain purposes, which is when somebody dies, the property that they have when it's getting passed on either through a will or through a trust, but based on their death, is being transferred to somebody, the date of death value, which is the value that's, number one, subject to estate tax, if there is any. But the property value is what now the person receiving it paid for it, so to speak. So if mom and dad had a house and you inherit the house and now you're going to sell it, if it was worth $500,000 on the date of death and you sell it for $500,000 because you sold it soon thereafter, there is no capital gain because it's that basis that you have in it now of $500,000 as if you bought it for that amount. So when you sell it, there's no gain. So there's no capital gain on that. Or if you keep it for a while and then sell it later, the gain is based on whatever the difference is between the sales price that you net actually and what you inherited it for. There's some thought that that might change.
A rumor.
A rumor. And what is the estate tax federally going to be? It's over $11 million right now. Will that change? Will it stay the same? It's scheduled to sunset in some years anyway and go back to a lower number, but what will happen with that? So that's all some things that go into the planning that we do. So it's possible that it's something that if you're at least concerned about those numbers and those types of things, or to say, hey, can we look at my plan again? Is there anything I need to think about or anything I can do?
So we often say, gee, who needs to have a will or who needs to have an estate? Only the rich. No, not only the rich. But as we're talking about this particular issue about how capital gains may be changed, how that exemption may change, there was a number floating around about $23 million. Not everybody is in that category, certainly. So these changes, this is a good time to explain, this is not just about those who are very wealthy who are going to be impacted by that time of death cost of the property. It's going to affect others now. How many, or what would be is it the middle class now as well?
Well, we don't know, because we
Could
don't
it
know
be?
what's
Let me
actually.
qualify that too.
Anything is possible. It could be. And to go back to the original point you were making about, I don't have a lot of assets. Well, do you have a house? Do you have a retirement plan? Do you have life insurance? Do you have a car? I mean, most people who have any of those assets really need to start thinking about, what am I going to do and how is it going to get to my children or my spouse or whoever you want it to go to. So everybody really needs to think about estate planning, but not only from what if I die, how is it going to get to the next person, but what if I live and I'm incapacitated? I don't want a probate court to appoint a guardian for me. I want to pick the person I want to take care of me and do the things that I want them to do, and I want someone I trust to know they know what I want and will do what I want. So there's those issues, and of course healthcare documents.
So if someone already has an estate plan and they've done it through an attorney, they might say, dear attorney, is it time for me to update it? And would you say, on balance, that most attorneys who are handling estate planning right now, they're likely to say, let's come in and discuss this because things are in flux, they're not decided, but the discussion and headlines certainly suggest that you may want to revise it. Do you think most people, most estate planners would likely say, yes, we should review this to consider the alternatives?
So for sure, they're going to say, are there any changes in your life? Do you have any more children? Have your children gotten married?
Any more divorces?
Any
in
more
the family?
divorces? Are there any changes in your life that you're concerned about that you want to address? So that's first of all the first thing. Also, are there any changes in your situation financially? Because that's the next thing. Are there any changes in yourself, health-wise or otherwise, that we need to think about and talk about? So it's, first of all, personal to each client and whether or not they have anything that's changed. And again, if it's been 5 years, 6 years, 10 years, whatever, certainly come in and talk about it, because there have been changes that you might want to think about and talk about. The other changes that haven't happened yet, it's a little difficult to say, come on in and let's talk about the possibility that there might not be a step up in basis, or that your children will be subject to capital gain, because we don't know that yet. So I wouldn't tell someone to come in just because of changes in the law that might happen, but I would tell them to come in to talk about changes in the law that have happened if it's been a while since their plan has been reviewed.
Okay, so you are now speaking in your capacity as a lawyer. Others who might have accountants, but not a lawyer that they see, more are seeing their accountants probably right now because it's tax season, even though there's been an extended deadline. I understand in a quick poll, very informal survey, I've asked accountants whether or not their clients have asked them anything about their situation changing because of COVID. So for example, maybe they were laid off, maybe they've had different retirement plans forced on them or otherwise. Most of them have said that no one wants to ask about what troubles may be on the horizon, maybe because they're involved just and only with taxes, but no one's going to look for, do I want to say trouble? No one's going to look for more work to be done at this point. A financial advisor, I guess every year at least someone is going to be reaching out to them and saying, time to review, your financial situation may have changed, your investments change. An investment planner, do you end up calling in financial planners, tax planners, now more than ever because of this, these situations being in flux? You're good, David, but you're not expected to do all of these things, are you?
So no. And I do have clients that sometimes I meet with and I say, we need to take a look at some things. So you've raised a few issues. Let's talk about some of those. The Secure Act that was 2019 changed some of the rules about retirement plans. And some clients who had old trusts that were called conduit trusts, where we would be looking to stretch out the inheritance of the children based on the oldest child's lifetime in the trust. It's a 10-year time frame for the most part. There are exceptions to every rule, but that's a change that you might want to look at. And one of the other changes from that Secure Act is do we want to make sure, and we always have had a lot of this language in our trust, for example, but in your planning as we're doing this, some of the bequests or gifts that you're making to charity, especially after you die and it's part of your estate plan, to make sure the language is in there that those get paid out of retirement plans. Because if your children would have to take out their share within 10 years, but you can get both the deduction for estate tax purposes, if that's an issue, and the ability not to have to worry about it becoming income tax to your children because the nonprofit doesn't pay income tax, there's some benefits of making sure that that's set up. And we're starting to look at maybe using what we used to call CRUTs, charitable remainder unit trusts, and starting to say, all right, let's take some maybe retirement assets that you might otherwise have some taxable problems with, estate tax or income tax wise, and create these charitable trusts that can pay you out money while you're alive, because it's a remainder trust, because the charity gets it at the end. So, and again, I'm working on things with people on that type of thing, and I would always want to bring the accountant in and say, all right, if we donate this property to that charitable remainder trust, how much income tax will we save on capital gain if it's a highly appreciated asset that we put in? And how much money will we save on estate tax if it's a deduction from estate taxes? And what are the other benefits of creating this charitable remainder trust? And how much income can my client get out of it while they're alive, which is part of the reason we do that.
Would you touch briefly on GRAFs?
CRATs.
CRATs.
Yep,
And,
CRATs
yes,
and CRUTs.
And CRUTs.
Charitable Remainder Annuity Trust, CRAT, Charitable Remainder Unit Trust, CRUT. And it depends what you fund it with, an annuity type of thing, or just property that you put in. You know, you have stock from 1959 that's grown incredibly well, and you want to fund the trust with that highly appreciated stock. So,
Or if you've had stock and it's decreased in its value right now, and that's not necessarily about that portion of it, but that's certainly going to impact on how you might want to change your trust to. If you've had stock that has been devalued and now maybe your retirement's changed, your other investments have changed, if someone's coming to you, are you immediately going to say, we need to bring in
the financial
the
planner.
financial person?
Yep. Yes.
Is it an accountant? Is it a financial planner? Is it both that you bring in?
It depends what the issue is.
Okay.
So if we're trying to create this charitable remainder trust, we probably really need to speak to an accountant because we know what the basis in the property is, and we know what we want to do with it. And certainly after it's in the trust, we might want to bring a financial planner in if there isn't already one to say, or a financial advisor, about the investment of what's in the trust. But to determine whether or not we want to create the trust, that's more of an accounting issue on what's the tax consequences of what we're doing. What do we save? What are the benefits?
Would you advise for someone who has not established an estate plan as yet, that they see a lawyer first, or just while they're working with their accountant, they wait until they deal with all of their financials, perhaps their financial planner to see where their investments are going, and then go to see you?
No, I would say you want to see the lawyer right in the same sequence with everybody else. Whether the financial planner is going to tell you what you should be investing in and how that affects the plan isn't that significant. So whether you do it before or after doesn't really matter to me. What I want to do is I want to look at the whole picture. I want to talk to you about what the picture is. And then if you tell me, well, I'm going to go to this stockbroker or this other financial advisor and this is what I want to do, well, that's great. That's what they're there to advise you for. I'm going to tell them and you how we should title it. Should it be titled to a trust? Should it be titled jointly? How do we want to make sure it gets to where you want it to go and does it in the best possible with the best possible tax consequences, if that's such a thing.
So, yes, you may know many things that you don't have a crystal ball. When you think about how long generally things take, we know that many did pedal to the metal, so to speak, during the pandemic. They were panicked and wanted to get things done as quickly as they can, even if they weren't done properly. How long would you say that these this process takes. I understand that financial planners can say putting those documents together can take a very long time. When you're talking about estate planning and you're renaming documents, how long does that typically take for someone who has properties and investments and accounts? What do you look at?
It does depend on how complicated you want to make it.
Granted.
So if we're going to create some revocable trusts and all the other documents that go with it, the pour-over will, the power of attorney, the healthcare power of attorney, the living will, the power of attorney for trusteeship, just to name a few, then to sit with the client and go through the process of determining what they need and how best to plan that estate, that's a couple of visits. That might be something done over the course of a month or so. Then you have to draft it. That might be another month, so they come back and sign it. And then you have to fund it, because in order for the plan to work properly, the last step is the funding. And what we want to do when we do a plan is to make sure that the assets that belong in the revocable trust, for example, get into the revocable trust. The insurance that belongs in the irrevocable life insurance trust gets into the irrevocable life insurance trust. And the other gifting trusts that we've created, the assets that need to go into those irrevocable gifting trusts get into those trusts. So that last step might be another month. So is 3 months fair to do all of that? That's fair. Sometimes because of the client schedule, it might be 4 months.
Good to know. And also, when people are in the process of figuring who's going to be their trustee, how important is it that you or your client connect with that person to either review the documents or where they are? How does that play out? Let's give some practical advice to our viewers.
Certainly it depends who they're going to pick. If they want to pick a professional, then you want the professional to be aware that they're part of a document that they're going to be named in. And certainly it's not unfair if it's a trust company, for example, to say, well, we want to see it before we'll agree, because if they're going to be in it, they want to know what they're signing up for. If it's an individual, it's not unreasonable to say if they're going to be involved from the outset, they have to know that they're involved because they're part of the process. And it's reasonable to bring them in and say, this is what's expected. Do you feel like you can do it? If it's someone who's going to play a role down the road, it's a conversation you should have to make sure they're willing to do it. So part of the process when we do the design, and that's a big part of the process, is to talk about what the roles are, explain the roles, and make sure that we're picking the most appropriate people or institutions or professionals to fill those roles.
I know we talk about who's best suited in each role. Recently, and we're hopefully over this now, I'm sure that people would come to you and say, I need to have my electric bill paid if I'm in the hospital. I need to pick my brother Joe because he's down the street and he actually has my key and can get in. Hopefully we're beyond that.
Yeah, I mean, there's a lot of people who are close that might not be able to really do the proper job. And there are people who are farther away that might be able to do the proper job. And with the internet and cell phones and all those things, sometimes you don't really need the closest person to make those decisions for you. Sometimes you do. And so it depends on your unique situation. And that's what we talk through when we decide and help you decide who's going to help fill that role the best.
Good, thank you. We hope that this has been helpful to you in your considerations for wills and estate planning. We hope that you will continue to stay tuned to The Law Matters. As we say, it matters to you. Thank you for tuning in.